"Get that girl out of my courtroom." Officer Dale Whitmore said it loud enough for the whole gallery to hear. He didn't bother to lower his voice. He didn't look at the bailiff when he said it. He looked directly at her, at the 17-year-old, sitting in the second row with red eyes and a tissue pressed to the corner of her mouth, and he said it the way a man says something he has said 100 times before. Like it cost him nothing. Like she cost him nothing. Her name was Amara. She was crying because her mother was the defendant. She was crying because the handcuffs were too tight on her mother's wrists, and her mother kept her chin raised anyway, and Amara could see the exact moment her mother decided not to let them see her cry. So Amara cried for both of them. She cried quietly, the way girls learn to cry when they need to be invisible. And Officer Dale Whitmore laughed. It wasn't a big laugh. It was a small, contemptuous sound. A breath through the nose, a little shake of the head, the kind of laugh that is worse than a big one, because it doesn't even find you worth the full effort. He turned to the officer standing beside him and said, under his breath, but not under it enough, "These people." Amara didn't flinch. She looked up. She looked Officer Whitmore dead in the face with eyes that were wet but steady, and she did not look away. Nobody in that courtroom moved. Nobody spoke up. 26 people sat in those wooden pews and watched a grown man in a badge mock a crying child, and not one of them made a sound. He had no idea who she was. He had no idea what she was carrying in her lap at that very moment. A slim leather notebook, dark brown, worn at the spine, with 3 initials embossed in gold on the lower right corner. He couldn't read those initials from where he stood, but those 3 letters were about to change everything for him. Officer Dale Whitmore thought that was the end of it. He thought that was just a Tuesday. He just made the most catastrophic mistake of his career. Have you ever been the one who cried while the people with power laughed? Have you ever sat in a room where you were the least important person there, and you knew it, and everyone else knew it, and they made sure you knew they knew it? Let me take you back 7 years, before this courtroom, before Officer Whitmore, before any of it. Let me take you back to where Amara begins. The house on Tillman Street in East Grayfield was the kind of house that had been held together by love, for longer than it had been held together by its structure. The porch step on the left side had a wobble that her mother, Diane, had been meaning to fix since the spring of 2011. The kitchen ceiling had a brown water stain shaped vaguely like the state of Florida that appeared every winter and disappeared every spring, and they had named it Harriet, and Harriet was as much a part of the family as anything else. There were 3 locks on the front door. The third one, the deadbolt, required you to lift the handle slightly while you turned the key, and if you didn't know that you'd stand there for a full minute wondering why the world had locked you out. Amara knew. Amara had known since she was 10. She was the only child of Diane Josephine Okafor, née Hargrove, who worked the early shift at the county hospital in the dietary department. Not a nurse, not a doctor, not someone the hospital put in its brochures, the woman who made sure the food got to the rooms, who memorized the dietary restrictions of every patient on the 3rd floor without writing them down, who knew that Mr. Castillo in 312 needed his oatmeal unsalted and that Mrs. Weatherby in 318 would not eat anything green on a day her daughter hadn't visited, who kept a small bottle of lavender hand lotion in her scrub pocket because hospital soap dried your skin down to the bone, and because a little dignity, even in small things, cost nothing and meant everything. Diane was at work by 5:30 in the morning, while the sky was still that particular shade of gray that is neither night nor morning, the street quiet enough that you could hear the 3rd lock click. She was home by 2:30 in the afternoon. She never missed a school play. She never missed a parent-teacher conference. She never missed a Sunday service at Greater New Hope Baptist Church, where the pastor's name was Reverend Dr. Samuel Atcheby, and where the choir wore burgundy robes, and where Diane sang in the 2nd soprano section, with the kind of voice that didn't stand out so much as it held everything else together. The kind of voice you only notice when it stops. On the first Sunday of every month, she wore a brooch that had belonged to her own mother, a small gold cameo, oval-shaped, with a woman's profile pressed into it, and around the edge a tiny inscription that you needed good eyes or good light to read. Amara knew what it said. She had read it 100 times, pressed her thumb across those small raised letters the way a person presses a wound to make sure it still feels like something real. She is more precious than rubies. That brooch lived in a small velvet pouch in Diane's dresser drawer, except on the first Sunday and on the days that mattered most. It had survived Diane's mother and her mother's mother and 3 moves and 1 fire, and it was the most valuable thing in that house on Tillman Street, not because of what the gold was worth, but because of what the gold remembered. Amara had her father's eyes and her mother's stillness. People who didn't know them sometimes thought she was aloof. People who knew her knew the difference between cold and careful. She was the kind of girl who listened before she spoke, who read the room before she entered it, who took notes. Real notes, not keystrokes, but pen on paper. In a brown leather notebook she had bought herself with 3 months of babysitting money when she was 14. She had her initials embossed on the cover at a craft fair for $4, AJO Amara Josephine Okafor. She carried that notebook everywhere. By the time she was 15, Amara had filled 4 of them. What was in those notebooks? Anyone who found one would have needed time to understand what they were reading. Case citations, judicial opinions, statutes, constitutional provisions, annotated in her own hand. She had started with her mother's case, a minor billing dispute with their landlord that had escalated, as these things have a way of escalating, into something no one had intended. And she had spent 6 months reading everything she could find about tenant law, civil procedure, the burden of proof, the standard of review. She read the federal rules of evidence at the age of 14, the way some kids read fantasy novels. She read them with a highlighter and a dictionary, and she read them twice. Where did this come from? People would ask that later. They would ask it as though the answer must be somewhere exotic, some hidden resource, some miraculous intervention. It came from the shelf above the TV in the living room on Tillman Street. That shelf held 17 books. 4 of them had belonged to Diane's father, Amara's grandfather, Ezekiel Hargrove, who had died when Amara was 4 years old and whom she remembered only in fragments. The smell of cedar and newsprint, a hand that was very large and very gentle, a voice that read to her from whatever was nearby. He had been a postal worker for 31 years, and he had read constantly and widely, and somewhat randomly, history, biography, law, science, whatever the church library passed along. Among the 17 books on that shelf was a worn paperback edition of a guide to American civil procedure, the kind sold in used bookstores for $2, with underlinings in blue pen that were Ezekiel Hargrove's handwriting. Amara had found it when she was 12 and looking for something to read during a power outage. She had read 40 pages before the power came back. She hadn't stopped. She had never met a lawyer. She did not know any judges. She had no model, no mentor in the traditional sense, no one who sat across a table and told her what to do. What she had was her grandfather's underlining and her mother's patience, and a brain that operated on the specific frequency of systems thinking. The ability to look at a set of rules and understand, with unusual speed, exactly what the rules were designed to prevent, and exactly how someone might be getting around them. She had been 14 when she first underlined something in her grandfather's book. She wrote in the margin next to it, "This is how Mama's landlord wins." She was 16 when she figured out how to make him lose. She had not told her mother the full scope of it. There is a kind of silence that is not absence. There is a kind of quiet that is the sound of something building underground, accumulating mass and pressure for so long that when it finally moves, the people standing on top of it have no frame of reference for what is happening to them. That was Amara. But before we get to that, before we get to the moment when the ceiling came down on Officer Dale Whitmore, you need to understand how the ceiling got up there in the first place. You need to understand the system that had been protecting men like him for a very long time. Officer Dale Whitmore had been with the Grayfield City Police Department for 19 years. He was not a bad officer in the dramatic sense. He did not make the news. He had not been the subject of a federal investigation. He had no use of force complaint that had resulted in any official consequence. What he had were 37 complaints in his personnel file that had each been reviewed, categorized, and closed. Discourtesy, failure to provide badge number, Racially disparate enforcement, excessive tone. 37, closed, every one of them. His supervisor, Lieutenant Creighton Pell, had served on the department for 24 years and had reviewed 11 of those 37 complaints personally. Pell had been Whitmore's training officer in year 1. They had coffee together on Tuesday mornings at the Sunrise Diner on 4th Street, and they each took their coffee the same way, black, no sugar. And they had each, over 20 years, covered for the other in the manner of men who believe that loyalty is the highest virtue, and have never been asked to account for what their loyalty costs other people. The Grayfield Police Union had a provision, buried in Article 14, Section 3 of the Collective Bargaining Agreement, in language so opaque it required 2 reads and a legal dictionary, that required any civilian complaint to be reviewed by a 3-officer panel before it could be elevated to the department's Professional Standards Bureau. The 3-officer panel was appointed by the union president. The union president had been Dale Whitmore's academy classmate. 37 complaints, closed. This is the system that stood behind Officer Whitmore when he laughed at Amara Okafor in courtroom 6 of the Grayfield Municipal Court. This is the floor he was standing on. This is why he laughed the way he did, not with fear, not with hesitation, but with the deep, unquestioned ease of a man who has never in 19 years felt the floor move beneath him. He didn't know the floor was about to open up. Now let me tell you about the thing that brought them all to that courtroom in the first place, because you need to feel the full weight of it. Diane Okafor had been renting the house on Tillman Street for 11 years. She had paid on time every month by money order, because the landlord, a man named Clifford Marsh, who owned 9 properties in East Grayfield and lived in a subdivision on the west side, did not accept personal checks or electronic payment. He preferred money orders. He did not provide receipts. He said this had never been a problem. He said this to every tenant in all 9 of his properties, and for most of them it had not been a problem. Not until it was. In November of the year Amara turned 16, Clifford Marsh filed an eviction notice against Diane Okafor, claiming 11 months of unpaid rent, $4,950. He said she had not paid since December of the prior year. Diane had every money order stub in a shoebox under her bed. She had proof of purchase. What she did not have, because Marsh had never provided them, were receipts of delivery. The money orders had been cashed. Marsh said he didn't know anything about that. He said someone else must have cashed them. He said this with the confidence of a man who had done this before, because he had. Amara found the pattern in a single evening. 3 prior tenants, same landlord, same sequence of events. One of them had left the state. One of them had taken a settlement. One had gone to housing court without a lawyer and lost. 3 people whose documented proof of payment had been insufficient against a landlord who understood exactly how to exploit the gap between a money order stub and a cashed receipt. Amara wrote 14 pages of notes that night in her brown leather notebook. She wrote the name of every applicable statute. She wrote the case number of every precedent. She wrote down the questions she would need answered and the documents she would need to obtain and the procedural motions she believed could be filed. She wrote at the top of the first page in her careful handwriting, "They have done this before. That matters." She was 16 years old. She helped her mother find a legal aid attorney. She prepared the file her mother brought to that attorney, organized, tabbed, cited. The attorney later said it was the most prepared client intake she had received in 14 years of practice. She did not know, at the time, who had actually assembled it. The legal aid attorney's name was Patricia Vance. She was competent and overworked and underfunded, and she did what she could, and what she could do, in the time she had, was enough to keep Diane in the house while the case moved through the system. But the case moved slowly. These things always move slowly when the person with the money is not in a hurry. And while it moved, Amara kept writing. She wrote to the State Bar's Tenant Rights Project. She sent a 4-page letter, organized, cited, with exhibits attached, identifying what she believed was a pattern of fraudulent eviction filings by Clifford Marsh. She did not sign it with her name. She signed it, A. Okafor, on behalf of the affected tenants. She was 16. She did not know whether they would take it seriously. She sent it anyway. She did not tell her mother about the letter. What she did not know was that a senior staff attorney at that project, a woman named Catherine Selby Rhodes, had read the letter twice, then read it a third time, and had forwarded it with a single note to her supervising partner. Who wrote this? But that's a thread for later. Remember that. Remember the letter. Now let's go back to courtroom 6. The hearing was a status conference, routine, procedural, the kind of thing that takes 20 minutes and means nothing in the long view of a case, except that Amara had come anyway, because she came to everything. She sat in the gallery with her notebook open on her lap. She had been taking notes since the clerk called the case. Patricia Vance was at the plaintiff's table, reviewing something in a folder. Marcia's attorney, a man named Garrett Holloway who wore cufflinks on a Tuesday morning and who had, by Amara's count, filed 4 motions in 30 days, all of which amounted to delay, sat at the defense table looking comfortable in the specific way of a man who is comfortable because discomfort is something that happens to other people. And Officer Whitmore was there because Garrett Holloway had filed, the week prior, a motion to have the hearing secured by a uniformed officer, a status conference, a secured status conference. Amara had written in her notebook, intimidation tactic, note for record. It was during the second recess that Amara's eyes had filled. She had watched her mother sit quietly while Holloway made a speaking objection that had nothing to do with procedure and everything to do with making Diane look at her lawyer instead of the judge, and something about the smallness of it, the calculated, practiced smallness of what money could make a man do to another person, had climbed up into her throat, and her eyes had gone wet before she could stop them. She was still holding the notebook. She had been holding it since she sat down, the way you hold something familiar when the world feels like it is tilting, the brown leather warm in her hands, the gold initials under her thumb, AJO. She pressed her thumb across them the way she always did, and that was when Officer Whitmore turned around and said what he said. "Get that girl out of my courtroom," and laughed. And then, and this was the moment that Officer Demps captured on video, the moment that 2.1 million people would watch, the moment that would become the image. Whitmore reached out and flicked the corner of the notebook in Amara's hands. Not hard, not violently, just a small, contemptuous tap, the gesture of a man batting away something beneath his notice, the gesture of a man who wanted her to drop it, to flinch, to feel the smallness he was assigning to her. The gold-embossed letters caught the fluorescent light for 1 second. He didn't know what those letters meant. He didn't know what that book was. He said, just loud enough for the officer next to him to hear, "These people." The bailiff at the front of the room went still. The gallery went still. A woman in the third row put her hand over her mouth. Amara did not drop the notebook. She pulled it closer to her chest, one hand on the spine, and she looked up at Officer Whitmore with eyes that were wet but absolutely, perfectly still. And she held his gaze for a count of 4 seconds, 4 full seconds, before she looked back down at the page and resumed writing. He had touched her grandfather's notebook. He had put his hand on it and found it lighter than he expected. He had no idea what he had done. Officer Travis Demps, the young bailiff at the front of the room, 3 years on the job, the one who had frozen, said later, in a sworn statement, that he looked at the judge's door when it happened. He had been trained on courtroom security and on crowd control, and he had not been trained on what to do when a 19-year senior officer mocked a black teenager in a gallery while nobody moved. He said he looked at the judge's door. He said the judge was still in chambers. He said he looked back at the girl. He said she wasn't crying anymore. He said she was writing. She was writing. Her hand was steady on the page of her brown leather notebook, and she was writing with the same focused calm that she brought to everything. And if you had been close enough to see what she was writing, you would have seen that she had written down the exact time, the exact words, and Officer Whitmore's badge number, which she had read from across the room because she had been reading badge numbers since she was 14, and had taught herself the habit the way you teach yourself any habit that survival requires. Badge number 2247. Dale R. Whitmore. She wrote it down, and then the judge's door opened. But what Amara didn't know, and what Officer Whitmore absolutely did not know, was that the judge who was about To take the bench was not the judge who had been scheduled for that morning. Judge Harold Fitz had called in sick at 7:42 a.m. with a stomach issue. The clerk of court had made 2 calls before reaching a substitute. The substitute had already been in the building, had in fact been in a meeting down the hall, and had agreed to take the morning calendar as a professional courtesy because that is the kind of judge she had always been. Her name was the Honorable Constance Adaeze Okafor Nwosu. She was 54 years old. She had served on the Grayfield County Circuit Court for 9 years. Before that, she had served as an assistant United States attorney for 11 years, and before that she had clerked for a judge on the Fourth Circuit Court of Appeals, and before that she had graduated second in her class from Howard University School of Law, and before that she had grown up in a house on Tillman Street in East Grayfield, in a house where the porch step had a wobble, where the kitchen ceiling had a water stain they called Harriet, where 3 locks on the front door required you to know the trick of the third one. She was Diane Okafor's older sister. She was Amara's aunt. And she had been a judge long enough that when she walked through that door and up to that bench, she did not look like someone who had been a crying teenager once. She did not look like someone who had sat in a gallery with wet eyes. She looked like what she was, a Federal Circuit-trained, 20-year veteran of the law, in a black robe with a nameplate on the bench that read, "The Honorable C.A. Okafor Nwosu." And then the clerk of court looked up from his desk and said, in the flat professional voice of a man doing his job, "All rise." The Honorable Constance Okafor presiding. The gallery rose. Officer Whitmore rose too automatically, the way you rise when you've been doing this 19 years. And then he looked at the bench. The color left his face in a single second, not gradually. Not a slow drain. It left all at once, the way the light goes when a circuit breaks. His mouth, which had been set in that comfortable, slightly bored line of a man who owns the room, went slack. His eyes, which had spent the last 20 minutes performing their small, daily cruelties, went wide and then went still, like a man watching something come toward him that he has no category for. The judge settled her robe. She looked at the docket. She did not look at Dale Whitmore. She did not need to. She had been in rooms like this her entire professional life, and she had learned, very early, that the most powerful thing you can do is make someone wait. "Be seated," she said. Everyone sat. She said, "We're here on Marsh versus Okafor, case number 24 CV 0881, scheduled status conference." She looked up. She looked, for a single measured moment, at Amara in the gallery. Something passed across her face. Not a smile, not a wink, not any visible display of recognition, just a moment's regard. The way you look at something you love when you have trained yourself over 20 years not to show it in public. Then she looked at Garrett Holloway. She said, "Counsel, I've reviewed the docket. I count 4 motions in 30 days, all substantively identical, all seeking procedural delay. I'm going to give you one opportunity to explain to me why the next one I see should not result in sanctions." Garrett Holloway straightened his cufflinks. He said, "Your Honor, we believe the plaintiff's documentation," she said. "I didn't ask about the documentation. I asked about the motions." The room was very quiet. She said, "We'll take a brief recess. I want to see both counsel in chambers." And she paused, and now she did look at Officer Whitmore, briefly, directly, the way a judge looks at a thing she intends to address. "And I want to speak with the security officer on record." She stood. The clerk said, "All rise." Everyone rose. And then the judge, passing the bench on her way to chambers, looked one more time at the gallery, at the second row, at the girl with the brown leather notebook, and Amara, for the first time since she had arrived in that courtroom that morning, exhaled. In chambers, it did not go well for Officer Whitmore. It did not go well in the precise, methodical, documented way that things do not go well when a Federal Circuit-trained judge has heard a first-hand account from a bailiff, has reviewed courtroom security footage from 2Ls, and is writing on a notepad as she speaks to you. She did not raise her voice. That was the worst part of it, the officers later agreed. She was completely, utterly calm. She said, "Officer Whitmore, you are in my courtroom, not your patrol vehicle. Not a holding facility, not any space in which you have discretionary authority over who is and is not permitted to be present. The gallery of a public proceeding is open to the public. That young woman was lawfully present. She was not disruptive. She was grieving, and you elected to mock her. She said, "I am going to tell you two things. First, I am reporting this incident to the Professional Standards Bureau directly, not through the Union Review Panel, directly, under my authority as a sitting judge of this court, who personally witnessed the conduct. Second, you are relieved from this courtroom. You do not come back into this building today." He opened his mouth. She said, "I'm finished speaking to you." He left. But the chambers meeting was not the only thing happening in those 20 minutes, because what Amara had done in the recess was not sit quietly in the gallery and wait. What Amara had done was take out her phone. She had sent a text message to a number she had saved under the name Miss Selby Rhodes. Legal aid. The text said, "I'm in courtroom 6. Something happened. I think you should know. Can we speak after?" Catherine Selby Rhodes, the senior staff attorney at the Tenant Rights Project, who had received Amara's 4-page letter 8 months earlier and had never been able to stop thinking about it, who had, in the intervening months, opened a formal investigation into Clifford Marsh's rental practices based substantially on that letter, was 3 floors up in the same building for an unrelated matter. She read the text. She came downstairs. She arrived in the gallery just as the recess ended. She arrived just as Amara was putting her phone back in her pocket. She sat down beside her, this 51-year-old attorney with 22 years of housing law, and she looked at this 17-year-old girl with her brown leather notebook, and she said quietly, "Are you A. Okafor?" And Amara looked at her and said, "Yes, ma'am." Catherine Selby Rhodes said, "I've been looking for you for 8 months. But we're getting ahead of things." What happened next, publicly, in that courtroom, was itself already enough to change several lives. When the judge returned to the bench and the session resumed, she addressed the record. She stated clearly, for the transcript, that she had personally observed conduct by a uniformed officer in the gallery that she was characterizing as intimidation of a lawful observer, and that she was ordering the matter referred to the department's Professional Standards Bureau under court authority. She stated the name. She stated the badge number, 2247, Dale R. Whitmore. She said it into a microphone that was recording every word. Officer Travis Demps, the young bailiff, had been sitting at his station with his stomach in a knot since the morning. He had not spoken up when it happened. He knew he had not spoken up when it happened. He had 3 years on the job, and he understood, in the way that young officers in departments like Grayfield's understand, what speaking up cost. He had watched it happen. He had watched a teenage girl with red eyes get mocked, and he had looked at the judge's door, and he had not moved. But he had his phone. He had a video. 14 seconds from the moment Whitmore turned to the gallery to the moment Amara's eyes went back to her notebook, and Travis Demps had recorded it in the grip of some instinct he couldn't fully articulate. The same instinct that had made him a cop in the first place. The instinct that what was happening was wrong and that wrong things should be witnessed. He gave the video to the Professional Standards Bureau investigator at 4:30 that afternoon. By 7 o'clock that evening, the 14-second clip had been sent by a court clerk who had heard about it from a colleague, who had heard about it from Travis Demps, to a local news journalist named Maya Osei, who covered courts and policing for the Grayfield Courier. Maya Osei had been covering the Grayfield PD for 6 years. She had 3 outstanding public records requests about officer complaint files sitting unanswered on the department's desk. She watched the video 4 times. She called her editor. She said, "I need to go tonight." The story ran the next morning. 14 seconds of footage. A teenager with wet eyes. A uniformed officer's laugh. The caption read, "Officer 2247 mocks grieving teen in Grayfield Municipal Court. Judge removes him from proceedings." By noon, it had been viewed 430,000 times. By the following morning, it had been viewed 2.1 million times. The hashtag was simple. It was 3 words. It was the words he had said to the man next to him, low but not low enough, and which had been caught on audio by the court's recording system. These people began trending in Grayfield at approximately 9 o'clock that first morning. It was national by noon. It was global by evening. The phrase, his phrase, His contemptuous, murmured phrase became the architecture for something he could never have imagined when he said it, because the people who used it in inversion, used it in reclamation, used it to mean the opposite of what he had meant, used it with photographs of their grandmothers and their daughters and their aunts and their mothers who had sat in rooms and been reduced to these people and who had not flinched, not one flinch. The Professional Standards Bureau investigation was initiated within 24 hours of the judge's referral. This was notable because in 19 years, no complaint against Officer Whitmore had ever reached the PSB directly. Every one of those 37 complaints had been funneled through Article 14, Section 3 of the Collective Bargaining Agreement, through the union-appointed review panel, through Whitmore's academy classmate. But a sitting judge's direct referral was not a civilian complaint. It did not go through the union panel. It landed on the PSB director's desk with the weight of judicial authority behind it. And the PSB director, a woman named Director Carla Osi Mensah, who had been trying to reform the department's complaint process for 4 years, and who had been blocked at every turn by the union, recognized immediately what she was holding. She did not slow walk it. The investigation ran for 11 days. It was thorough in the way investigations become thorough, when the person conducting them understands that the whole department is watching, and that the video has been viewed 2.1 million times. Investigators pulled the complaint file. 37 complaints. Investigators interviewed the union president. They interviewed Lieutenant Creighton Pell. They interviewed 5 of the 6 officers who had served on review panels for Whitmore's prior complaints over 8 years. What they found in those interviews would later be described in the formal investigative report as a systemic pattern of complaint suppression facilitated by informal network ties between the subject officer, the union review apparatus, and the chain of command. The report ran 44 pages. It recommended Officer Whitmore's termination. It also recommended a formal investigation into the conduct of Lieutenant Creighton Pell and the 3 union panel members most frequently assigned to Whitmore's complaints. The department's Civilian Oversight Board, which had largely been ignored for 6 years, held its first public hearing in 39 months on a Tuesday evening in March. The room was standing room only. 47 people gave public comment. The youngest was 12. The oldest was 81. A woman named Mrs. Evadne Parrish, who had lived in East Grayfield for 50 years, and who had filed a complaint against Officer Whitmore in 2019 for what she described as being made to feel like a criminal on my own porch. Her complaint had been closed in 10 days. She brought the closed notice with her. She held it up. She said, "I want to know who signed this." That question, Mrs. Parrish's question, asked into a microphone in a room with cameras, became the second thread of public pressure that the department could not ignore. The union was compelled under legal challenge to open its complaint review records for the prior 10 years. The review, conducted by an independent auditor retained by the city, found that of 93 complaints reviewed under the Article 14 process in the prior decade, 89 had been closed at the panel level without elevation to PSB. 89 out of 93. The auditor's report used the word irregularity 14 times. The city's Corporation Council, reviewing the auditor's report, used a different word, liability. The settlement negotiations began within 6 weeks. Clifford Marsh, meanwhile, was having his own very difficult spring. The Tenant Rights Project's investigation, which had been building for 8 months on the foundation of Amara's 4-page letter, concluded in April. They found a pattern across 7 properties. 22 instances over 8 years in which tenants who paid by money order had received eviction. Notices citing non-payment, in which the money orders had in fact been cashed by Marsh or his property management company, and in which the documentation gap, the absence of a receipt of delivery, had been used to leverage tenants into either abandoning their leases or accepting settlements that significantly undervalued their legal claims. 22 instances, 8 years, 22 families. The Tenant Rights Project filed a civil action. The State Attorney General's Consumer Protection Division opened a separate investigation. The AG's investigators later referred to Amara's letter, now entered as Exhibit A, as in their words, the most analytically precise intake document we received from any source in this matter. She was 16 when she wrote it. She was 17 when they read it into the record. The civil action against Marsh settled 11 months later for $3.7 million, distributed among the 22 affected families. Diane Okafor's family was one of them. The house on Tillman Street, the one with the wobble on the left porch step, the water stain named Harriet, the 3 locks on the front door, was purchased by Diane in the spring, after the settlement, with money that a court had determined was hers to begin with. She fixed the porch step herself. She left Harriet on the ceiling because some things earn the right to stay. Officer Dale Whitmore was terminated from the Grayfield City Police Department on the 31st of March. His termination letter cited the courtroom incident, the findings of the PSB report, and the pattern of complaint conduct documented in his file. Lieutenant Creighton Pell accepted an early retirement package in lieu of formal investigation. The union president did not seek re-election. The department entered into a consent agreement with the city council requiring Article 14 of the collective bargaining agreement to be renegotiated, removing the union-appointed panel process for complaints involving conduct documented on video or in official proceedings. The city allocated $1.2 million for an independent civilian complaint review office with subpoena power, something Director Osei Mensa had been requesting for 4 years, 37 complaints, 11 days of investigation, 44 pages, $1.2 million for what should have been built from the beginning. Travis Demps, the young bailiff who had watched and almost done nothing, and then done something, was recognized by the court's administrative office with a formal commendation. He said, in the brief statement he gave to the Courier, that he didn't feel like he'd done enough. He said, "She didn't flinch. I had to decide what that meant about me." He said he thought about that decision every day. He said he hoped he would always make the same one. The journalist Maya Osei won a regional press award for the story. In her acceptance remarks, she said the story was not hers. She said it belonged to every person who had filed a complaint that went into a drawer, and to the city that had finally been asked to open the drawer. But what happened to Amara herself? That's the part that deserves its own telling. Catherine Selby Rhodes, who had sat beside her in that gallery, and who had spent 8 months looking for the person who wrote that letter, did not simply thank her and move on. She invited Amara to the Tenant Rights Project office. She introduced her to the senior staff. She asked her, with genuine professional curiosity, how she had identified the pattern in the Marsh complaint data. Amara showed her the notebook. Selby Rhodes looked through 3 pages and sat back in her chair and said, "How old are you?" Amara said, 17. Selby Rhodes said, "What do you want to do with your life?" And Amara thought about it for longer than you might think a person would think about a question like that, when the answer should be obvious. She thought about her mother's wrists in handcuffs, chin up, refusing to be seen to break. She thought about Mrs. Evadne Parrish holding her closed complaint notice up in that room of 47 people. She thought about the 22 families. She thought about 22 families, and one woman who didn't know their names had decided at 14 to read the federal rules of evidence twice with a highlighter and a dictionary. She said, "I want to be a judge." She said it the way her mother sang in the second soprano section at Greater New Hope, simply, without performance, as a statement of fact about what was already true. That fall, Amara applied to 7 undergraduate programs with pre-law tracks. She wrote her personal essay about a woman's profile pressed into gold, and a sentence inscribed around the edge, and what it means to carry someone else's courage into a room and lay it down on the table in front of people who have already decided what you are. She was accepted to all 7. She chose the full scholarship. Catherine Selby Rhodes wrote her the kind of recommendation letter that makes admissions officers put it in a separate pile. In the letter she wrote, and this was later shared with Amara's permission, at an event honoring the young women of East Grayfield who had changed their community in a single year. She wrote, "I have practiced housing law for 22 years. I have reviewed tens of thousands of documents. I have worked with scholars and attorneys and federal investigators. The most analytically precise and morally urgent intake document I have ever read was written by a 16-year-old girl in a brown leather notebook at a kitchen table in East Grayfield because she loved her mother and she had decided that love was not enough, that love required tools. On the day before Amara left for college, her mother pinned the gold cameo brooch to Amara's jacket, the oval brooch, the woman's profile, the tiny inscription you needed good eyes or good light to read. She pressed it into the fabric and smoothed it with her thumb and said nothing for a moment. Amara said, "Mama, Diane said you carry her now." She meant her own mother. She meant her mother's mother. She meant all the women who had held something precious and not let it go across all the rooms that had tried to make them set it down. Amara wore it to her first day of class. She wore it to every interview. She wears it now. 1 year later, in the same building, one floor up from Courtroom 6, the Grayfield Bar Association held its annual recognition event. Among the honorees was the new Okafor Community Justice Clinic, funded by the settlement proceeds from the Marsh case and established by the Tenant Rights Project in partnership with the County Bar Foundation. The clinic provides free legal representation to low-income tenants in East Grayfield. It is staffed by volunteer attorneys, supervised by Catherine Selby Rhodes, and advised by a board that includes Director Carla Osi-Mensah, Maya Osi, and Travis Demps, who left courthouse security and enrolled in a criminal justice reform program in the fall. The clinic's first year, 214 cases, 41 evictions prevented, 19 landlord-tenant settlements totaling $840,000, returned to tenants who had been owed it $840,000, 214 families, 1 clinic, 1 year, named for a girl who cried quietly in the second row and wrote things down and did not flinch. Judge Constance Okfor-Nwosu was asked at the recognition event whether she had known who was in that gallery when she walked out of chambers that morning. She paused. She smiled the kind of smile that holds more than it shows. She said, "I knew her diaper size and her first word. I knew the trick to the third lock on the front door. What I did not know was that she had spent 3 years building a case that would outlast anything I could do from that bench." She said, "She didn't need me. I just happened to be there." She said this looking at her niece. Amara, from the second row, said nothing. She was writing in a new notebook. If this story reached you, if something in it landed in a place you recognize, share it. Pass it forward the way Amara passed it forward. Every person who needs to hear it and hasn't is someone else's Mrs. Parrish, someone else's 22 families. Subscribe if you want to find more stories like this one. And before you go, leave one thing in the comments. What is the room you sat in where someone decided before you opened your mouth that you had nothing worth saying? What did you do with that? Here's what really gets me when I sit with this story. It's not the cop who laughed, honestly. That man was who he always was. 19 years of closed complaints told us exactly who he was, long before he turned around in that gallery. The system was designed to make sure you never had to see it. What gets me is the girl with the notebook. Not the judge, not the lawyer, not the journalist, not the bailiff, not the advocacy organization with 22 years of experience. The girl with the notebook. The girl who decided at 14 that love requires tools, who read a federal rule book twice with a highlighter because she loved her mother, and she understood with a kind of wisdom that most adults spend a lifetime failing to arrive at, that righteous anger without preparation is just noise. She did not wait to be chosen. She did not wait for someone to hand her the door. She built the key, and then she built a door, and then she showed 22 other families where it was, and she did all of it quietly. She did all of it in a brown leather notebook with $4 worth of initials on the cover. AJO. You know what that tells me? That the most dangerous thing in any room is not the person with the badge, or the person with the settlement authority, or the person with the gavel. The most dangerous thing in any room is the person who decides that they are going to understand the room better than the room understands itself. So here is the question I want you to sit with. Really sit with it. Not the easy answer, the real one. Is there something you have been quietly building? Something you have written down, or thought about, or carried in a notebook or a drawer, or the back of your mind. Some understanding you have accumulated about a wrong that nobody around you seems to have named yet. And if there is, what is keeping you from sending the letter? Drop it in the comments. I read everyone.